broken baker, where crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We sing it's time to go. Whistling through this battering news, mixing stories, solving the lies. In this kitchen, secrets are broken, with a spark in our eyes. In the broken baker's kitchen, where secrets crumble like sunrise, we'll sift the blues to find the news. With a spark in our eyes, in broken rise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
Good morning, good evening, good afternoon, wherever you are, whoever you are, and welcome to this little impromptu stream of the Turtleboy court hearing. It's my first ever trying to stream a Zoom call. It might go good, probably won't. Looks on who's on first. Hey, Valhalla. Title. Hey, JVH. I am de la Casa Panini. Hey, Queen Olivie. Do you hear sound? Sorry, all. I can't figure out why it won't feed the sound through. I'm sorry. That's so weird because I heard it fine, and the lawyers are conferring in the background. And to the people saying, read the top bar. Uh, I'm not recording the webinar. I'm streaming it. Okay, works now. Now you can hear, and now I just got out of it. That's not good. Now I have to figure out to get back into it. This is working well. Marissa, why did you make me do this? Maybe I should remember there's a 10-second delay before you can see anything. Join a meeting. I already did that connecting. Enter pin code. Yeah, probably Marissa's fault.
Streams are posted afterwards. That's tech.
There should have been. I have a lady speaking very loudly about another case in my ears. I have no audio, no video, but I have a lot of audio, and I did the share the tab thing. Yes, it's not Aiden's trial right now. What the hell? Well, I can't get it to work. That's annoying. I really wanted to see this hearing. Uh, well, there's always trouble somewhere. Well, the problem isn't talking about Tennessee while we wait. The problem is making it work so we can watch it. And no matter what I do, I try to sign in twice. Miss Marissa, can you try and see if you can stream it through your end? Maybe Marissa can run it, and I can bring the audio in that way. Why is nothing good when I try to do it? It's just like my love life. Well, I heard all the other cases being called. There was a lady who didn't show up for court, who sent a notice. There was a guy who didn't show up for court. They wanted an arrest order on him, and now they wanted an independent evaluation of another lady's medical exemption. All the other channels are scared to stream it. Well, it does say don't record it, but I don't record anything. I just stream it. YouTube records it. And again, how can the court deny you the right to record a Zoom meeting, which is the same as a public court meeting? Well, I don't know, but the judge can try and put a gag order on me under his jurisdiction, which I'm not a part of, which has, as long as it's public. I don't know how a judge can say, first of all, it's First Amendment, baby. Second of all, he doesn't have me and Declarer isn't living in Massachusetts, so we can do it. It's the same in which case was it? Zachary Anderson, Holcomb, where the judge went out and said YouTubers aren't allowed to stream it. Only people on court to be. Ain't no such thing. Well, that's why I made a few anger babies while I was in Tennessee. Exactly. So that's just stupid. And yeah. Well, then I will have to serve a FOIA request, but still, it's just it's such a stupid thing to say because, of course, what if there's a reporter in court? Can't they do it? In Denmark, it's illegal to record in any court, but it's not in the Americas. I don't kiss and tell, but I would see his glow the next time he's on screens. Hey, Luna. Yeah, that's what I heard as well. They were calling other cases, but I saw Tom had a video from the courtroom. I didn't have that. The Young Jokes just said in his chat, the hearing hasn't started yet. He has some in calling telling him they are waiting. Yeah, we heard it in the background that the lawyers are talking. So it's nothing has happened yet. But I have Marissa on it, where she'll try to see if she can stream it through from her ends. Peter A, I can see your chats. I'm the captain now, and that's the most important. Hey, Panella, did you get rain today? You had a lot of rain. Oh, so nice today. I've slept for 10 and a half hours since yesterday. I'm a little tired. Bum, bum, bum. Well, some people care. Hey, Tom. Hey, Peter A. Period. Rain all day. Yeah, they talked about us getting as much as a month rain. It hasn't really rained that much. Higgin has a get out of court testimony card for tomorrow. Anyone seen the paperwork? I heard it's on X, but I don't have it. No. What I've seen today on X is they filed 3 or 4 new things they put in the state debt. One of them is an enhanced video, probably the dash cam video of the clearly shattered tail light. And then there's a medical thing on Higgins. I have speculated that the reason he needed a medical exemption could be because the Assy Grabbery might have been a little too hard with Bri, so he tore him up. And that's why Higgins have been so quiet and have a hard time sitting still. If he tries to come with a medical exemption, it should be because he needs a surgery. That's why I fell asleep before you ended yesterday, but apparently Bevy talked about Higgins should be done tomorrow. So if he has a major surgery Monday, it could be that. But on the other hand, she can't say the defense can't question him longer than that. Then she'll have to kick Lally's behind and say, you don't need to ask what size shoes he's wearing, what kind of underwear he wears, because the defense have a right to question him. And she said yesterday, we want him done Friday. And unless he has an illness that can only be healed by him getting that surgery Monday, so he can't participate in court, it'll be weird. Local news article say it won't be live streamed, but they may just mean the video will get posted after. 3 other channels have it, but no one is showing anything yet. No, again, lawyers are conferring. I have Marissa on it. She is trying in the background. For the audio, you may need to adjust how Zoom itself is transmitting the audio.
That can be a condition of release just on a straight bail. But what I will say is, regardless of whether it's in the court orders or not, Mr. Kelsey has already talked to me about beginning to work with the social work staff in my office to get the ball rolling there. Recognizing there's the significant penalties and the serious nature of the offenses, I think the presumption of personal recognizance, which we're not after personal recognizance, but the presumption of personal recognizance, the long track record of his appearance in court, the strong family support, he has no ties anywhere else, all really work in favor of a bail, I think, significantly lower than $20,000.
Now I lost audio. Oh, Marissa muted. Are you going to unmute when they come to Turtleboy? Because this is really loud and I can't hear anything else. Good kväll. I'm not Swedish. But good evening to you as well. No, Marissa muted the audio. So It's probably because it's still not Turtleboy going on. But we have audio now. That's the most important part. Sounds good. Sounds good. Exactly. That's why I found it weird when I arrived at the experts last Tuesday. The sign on the door saying pants were present, leave him outside. I thought, what? But no, you have to undress at the garage and you're just free flowing every time you're inside the house. It's a house rule. You get used to it, but it's weird just to begin with, especially because we were a lot of guys sitting on the porch that evening. Thank you. Yeah, I did the same thing, but mine just didn't go through, and I could see in my equalizer thing that it wouldn't go through one of the other channels. So I hope I can have you on backup, and then you can just unmute it when Turtle Boys comes on. Catskin toga sounds fun. Exactly. When in Dollywood, you better be Dollywooding. Luna, you should come next year, and we can talk about the hens and the chickens. Hey, Cindy, yes, how are you this fine morning? Pants are prison. Exactly. That's why I wear shorts. But again, they weren't allowed. Well, Marissa was pulling my chain and asking if I can do it, so I did it. No, neither does I. So yeah, that's good. You're looking for Flex Power Tools. They come with a lifetime warranty if you buy this year. Yeah, the Dollywooding was a thing, and it was an amazing thing going on. Let's just say I was surprised about the amount of Dollywooding. She's gonna run my channel from now on. I don't do anything the correct way. It's her. No, I only did one ride because my back can't do all the shifts and stuff like that. It's so we only did like a water ride. It was fun. Got a little wet, but that's the only one. Then I ate the worst burger in my life and tasted some of the best honey in my life. So it was a bit of an up and down stay at Dollywood. I'm getting a Dollywood vest. Always wanted bulletproof triple E's. Did I like the Philly cheesesteak? I think the bread in the one I got needed a little more crunch to it. It was like those reheated frozen breads. They're not good. They're never good. Yeah, I know TB means tuberculosis, but also means turtle boy. No, I'm not an expert. I don't see the video except on the mobile. What? What can my back do? Well, Luna, maybe you can fix it. Well, the expert didn't really do anything. It was the white rabbit. Talking about lovely people. Hello, Wendy H. Hope everything's fine and you are back in Califas. That's not what you said. You said me and Vegas Rick were the bane of your life and always making problems. Hey, white paint. Eddie sent you. Well, thank you for joining us, Brian. It's up.
Good afternoon, Your Honor. Steve Radel on behalf of Amy Carney. Your Honor, this is my client, Amy Carney, and this is specifically our paralegal. If you already
Good afternoon. That's fine.
Thank you very much. There's several motions on the docket today, Judge.
Yes. And are both sides prepared to address each of the motions?
I would say I am variously prepared, Your Honor, depending on the motion, and I'll indicate that as we go along, if I may.
Okay.
Mr. Bradel has, I think, a fairly lengthy list of things that you would like to address, so I'm happy to defer to him as to the, and to the court, of course, as to the order at which we take the particular motions up.
Okay. And I'll just note for the record as well, too, that obviously Special Assistant District Attorney Cosgrove used to be a member of the Superior Court bench, but we never worked together on the bench. So I just want to make that clear that there's no issue that I see. Attorney Bradel, are you raising any issue in that regard?
No issue whatsoever, Judge, and I should also say I've tried cases in front of Judge Cosgrove, and I'm happy to litigate against him as well. It's perfectly fine with me.
Okay.
Thank you.
Thank you. All right. So one of the matters that was outstanding from our last day in court was response to Attorney Bradel, your papers 6 and 16 in the 2023 case, which was the Commonwealth's reply to the defendant's motion to strike in reference to remedial orders and other matters. I know that there was a response that was filed to that by Attorney Mello.
Correct.
And that I believe that there may have been an issue, at least in the copy that I had received as to its completeness initially of what was filed. I'm not sure if you had received a complete copy of the filing as well.
Back to the judge, and you know, it was very brief.
Hey, Eddie.
It's not going to detain me in terms of what I want to argue today.
Welcome.
Court, and I was expecting him to be here in consonant with the court's order for people to be here in person today. That motion was on the docket. He had to have 3 deadlines before he complied with what he faxed to me and apparently gave an incomplete copy of to the court. And I'm here today before this court looking for satisfaction on my motion. His initial motion was denied.
Let me just pause you for 1 second. Attorney Cosgrove, are you ready to address that motion?
I think it would be better if it were addressed by Attorney Mello, Your Honor, but I do have some things to say about it.
Okay. All right. Well, why don't we address that, and I'll give you an opportunity of, and do we know?
Could I just say preliminarily, I became aware of the motion yesterday, and I came over to the court to get a copy of it, and discovered Attorney Mello's response. And in going through the papers in the court file, I discovered that apparently he had faxed over a response for filing with the clerk, and that for whatever reason, whether it was a misfunction on the fax machine or in scanning it in or whatever, the court appeared to have only a partial copy. I did contact Attorney Mello by phone yesterday. My understanding is that he did fax over a clean copy, and I'm hopeful that Your Honor has that before him.
I did receive the complete version, so I appreciate your efforts on that. And do we know, we're not going into any personal issues, what Attorney Mello's availability is going forward?
I can't say that with any certainty, Your Honor. He is not here today as a result of medical problems, which have been ongoing and recurring. When I spoke to him yesterday, he said he was in, I think the words he used were recovery mode again. So I think he's hopeful that he'll be back to good health, or at least workable health pretty soon, but I'm sorry I can't be more enlightening to you than that.
No, I appreciate that.
All right, a couple of things on that, Your Honor, was that the first thing is that we selected this date with Attorney Mello, fully aware.
Amazing Mello didn't show up again, and he's so sick, and he made a wrong filing. Thank you, Eddie, so much for becoming a member. And the link is on top of the description. Go over and check Eddie out, maybe after the stream, but you're welcome. And thank you so much for sending people over.
My fuse on this has grown very short, Your Honor. And, this is the fourth or fifth court date where, Attorney Mello had his side of this issue fully and fairly litigated against me by surprise, I might add, bringing witnesses to court without any notice to me from the jail, who testified without, I had no prep, no cross-examination whatsoever, that smeared me in open court about a simple mistake I made that had absolutely no practical effect on anything in the case whatsoever, and was made into some huge issue that was published in local media that damaged my reputation. I still have people coming up to me thinking that I somehow got in trouble because of Attorney Mello's ridiculous filings. And so I filed a cross motion for sanctions against him for several things. The first thing was publishing this motion without any regard for adequate investigation, without any actual truth to it, smearing me as if I was trying to manipulate the sheriff's office into confidential phone calls. So once I delved into it, I found that there were all sorts of avenues at the sheriff's office where all kinds of people could have confidential conversations through attorneys, through paralegals, without being a lawyer. The whole thing was a total sham, Your Honor. And so I filed my motion for sanctions against him for doing that to me. And in addition to that, Your Honor, in the body of his motion on the first page of it, he published my private cell number, Ms. Healy's private cell number, and Ms. Altman's private cell number in black and white on the first page of the motion, and published that to this court and put it on the docket. And from that day on, my email address has been hacked. My Facebook.
This is Turtleboy's lawyer, Bradel.
All sorts of things that I can't get into to this very day. And I'm not going to belabor it because I've given the court a paper record on it. I've filed an affidavit. Ms. Healy's filed an affidavit, and Ms. Altman's filed an affidavit. These women have suffered really nasty text messages and emails to them as a result of this. It was insanely reprehensible what he did. And that's just the tip of the iceberg, Your Honor. The conduct that he engaged in, publishing our private numbers, causing us all this harm, is exactly the same conduct that he indicted my client for. There's an indictment against my client.
Exactly.
For showing on his show, his internet show on video, a phone number of a state trooper, which resulted in him getting all sorts of hassles on his phone. That is the entire statement of facts relative to that indictment for felonious 13B witness intimidation against my client. And he does the exact same thing times 3 to the defense team, which is an eye-popping conduct, if you ask me, Your Honor. And and that dovetails into my motion to get him disqualified from this case. How do we deal with that? Is he going to take the fifth over this? How can he justify that he did it to 3 people and he indicted my client for the exact same conduct against one of his? What do we do with that fact? Is he going to be an expert witness? Do I call him as a witness to explain why his conduct is okay to the defense team and Mr. Carney's conduct is not okay? Why is his conduct felonious witness intimidation? And why does this Mello character get away with doxing all 3 of us, totally innocent people trying to do our jobs? He has this mentality that equating the defense team with what he perceives our client to have done. and it's some twisted form of revenge or some bizarre attempt to get payback for his trooper, it's just absolutely mind-boggling. It's unethical. It's gross misconduct. And because of all that, Judge, I have two requests asking you to disqualify him from this case. And on that point, Your Honor, I will say that that may become moot because the Commonwealth today served me with text messages from Attorney Mello to one of the complaining witnesses here, Ms. Gattani, where he tells Ms. Gattani in a text message that he is withdrawing from the Aidan Carney case. So I don't know what's going on with that, but I just received that. And, you know, if that's the case, let's have him fish or cut bait. Withdraw from the case within 7 days, or I want him disqualified. And that's my request. This insane, outrageous conduct needs to be answered by the court, and I appreciate that Your Honor is hearing this, and it's something that's been gone on through 3 deadlines for him to respond. He's ignored it. He's hiding behind his condition, and I am before the court asking respectfully for satisfaction on my motion, Your Honor. Thank you. And also there's this section on the apology, which I'll leave to the papers. Thank you.
Thank you.
So I would, somebody coming into this, obviously I represent the Commonwealth. I can't speak from an entirely objective point of view, but looking at Mr. Mello's motion and then looking at Mr. Bradle's cross motion, I would characterize it as something of a tit-for-tat motion. Mr. Mello was looking for sanctions, apparently, and Mr. Bradle responded by escalating the argument. I think that in reading Mr. Mello's response as filed by the court, he sets forth the factual basis that prompted him to file the motion, and one may agree, the court may agree or disagree with his decision to go forward on that, but I certainly think that he set forth the factual basis for his doing so, and I think that the exhibits that he attaches to his motion certainly enable the court to make an informed decision. I would suggest that the court could probably deny Mr. Bradle's motion on the paper submission, but I would also suggest that it's been maybe 7 years or so since I've had occasion to deal with the motion to disqualify counsel, but it's a pretty heavy lift, as I recall the case law. And if the court thinks that there is some merit to this motion, I think you need to have an evidentiary hearing with Mr. Mello here, and I think the court would need to make findings of fact. I think, frankly, the Commonwealth would have to seriously consider a 211-3 appeal if the court is going to be in the position of removing the prosecutor selected by the district attorney. That, of course, would be a decision for him, not for me.
All right. I agree that it does would require an evidentiary hearing on this particular issue. I know that there was a case recently out of Hampden County that was addressed by the SJC on a prosecutor who was potentially going to be a witness in a murder case that was going for trial out there. So that, I think, is going to set the standard of what needs to be addressed in terms of disqualification. So
if I could just add, Your Honor, I can't say this with certainty, but I am reasonably certain that the email purportedly from Mr. Mello talking about his withdrawing from the case was not actually sent by Mr. Mello, but was sent to Ms. Gattani, I believe, with someone pretending to be Mr. Mello. So I'm not at all sure that that's a genuine email, but certainly it indicated that he was planning on withdrawing within a week, and substantially more than a week has passed since that time.
Okay. So Attorney Brado, we had your motion there was actually discovery motions filed in the 23 and the 24 case seeking discovery, and I recall your arguments from the last date as to lack of discovery that had been provided at that point, and your inability to file either motions to suppress or motions to dismiss. I did see that EDA Cosgrove, that you had filed a letter that was sent to Attorney Bradel addressing discovery issues and your steps to address that. Do you want to be heard on that?
Yes, and I also provided Mr. Bradel with some additional discovery today, including grand jury minutes and a copy of the text that I alluded to in my letter from Lieutenant Tully. I did have the opportunity to speak with Attorney Bradel for a few minutes before we came up to address your honor, and he's provided me with a updated list of things that he's says he's missing. A lot of the information that was provided, maybe the lion's share was provided on some drives, and I'm advised that he has trouble opening some of those documents, or that the defense believes that certain things are missing. So I have a fairly, I think it would be fair to say, substantial list that he's provided me with today. And I've indicated to him that I will go right to work on looking into these things and either get them provided for them, or explain that we don't have them, or why we can't provide them. But I regret that I can't report that discovery is complete, but I'm working on it and I've done my best.
Well, your best isn't good enough, sir.
Yes, Your Honor, and I appreciate that counsel on the case is going to probably have a very different rate of production, shall we say, of discovery than prior counsel, and I'm not too worried about it. We've given the court the same chalk that I gave to counsel. It's the second one we've given you relative to the things we're looking for. And we are greatly prejudiced, Your Honor, in that this is really a kind of a case of first impression where, you know, we contend that journalistic activity has never before been a basis for felonious witness intimidation. So, you know, there's a lot of things that we need here. And we are very eager to relieve Mr. Carney this prosecution through a motion to dismiss or a motion to suppress. And we can't do so for all this time, for months and months and months, because we don't have the full copy of the grand jury. And I appreciate counsel trying today to give us some grand jury, but we already had that one. And we put it in here of what we actually do need. And we need the exhibits. And, you know, we need a full copy of it, and we need a representation from the Commonwealth that we do have everything in terms of grand jury. So I can do those McCarthy, Odell motions and motions to suppress.
So I did at our last date also instruct Attorney Mello to file a certificate of discovery with the court as well, too, as to what has been provided.
Correct. That was the first thing we put on here. We don't have any discovery notices. And you know, I do need a representation at some point, and I'm going to ask for it within 14 days, Judge, or I'm going to move for failure to prosecute, dismissal for lack of prosecution, because, you know, Mr. Carney deserves his chance to get out from under this case. And and I'm not talking about present counsel for the Commonwealth, but the Commonwealth itself has been slow walking this case to keep Mr. Carney away from the Karen Reed murder case that he's been seeking to investigate. And there's been all sorts of hurdles on that, and that's just been continuing. And he deserves to get that motion to dismiss filed And we want to talk about the constitutional issues and the Supreme Court and how most, if not all, of his speech in these cases, Your Honor, has already been covered by the Supreme Court in Brandenburg, in Watts. It's political hyperbole. It's First Amendment protected speech. It should not be the subject of a jury trial or any kind of trial. It needs to be addressed by a judge applying the First Amendment and the Supreme Court precedent. There's no way they can get past that in my legal view. And we're deprived of the opportunity to litigate that. We've been in a holding pattern for all this time. Your Honor said May 8th, nothing happened. Your Honor said notice of discovery, nothing happened. And again, present counsel accepted he wasn't there. It didn't happen. You know, these are all court orders that have been ignored. Like I said, 3 deadlines for my motion for sanctions, ignored. You know, and he gets the benefit of it rather than gets a sanction for it. And I'm asking that, you know, when a motion is not adequately responded to, when things are ignored by the court, you know, the court has options, and the court can deem a motion allowed for failure to respond. The court can provide sanctions. If the government is not providing fundamental discovery that we're entitled to without a motion, and they're ignoring our motions for it, I mean, they're not prosecuting the case, and it's a lack of prosecution. And I think the court, anytime on the record that we've assembled today, could dismiss this case for lack of prosecution, both of these cases. You know, there's no written motion before you, but I want to ask the court to enter an order that, you know, within 14 days, everything needs to be complied with, or you will entertain a motion for dismissal due to lack of prosecution. And I'm sorry that falls on present counsel's feet, but I'm not hearing that Attorney Mello's off the case. So if this is still Attorney Mello's cake that he's baking, then he's on the case, and let's make it happen. And that would be my request, Your Honor. Thank you.
Yeah, Cosgrove, is that a realistic time frame for you to ensure that the outstanding items under you just received notice of it today? To
Their case.
What's realistic?
Give me 30 days, Your Honor.
30? Why? Why? Again,
I would note that I'm not convinced that all of the things listed are missing are what I would call mandatory discovery, but I will look into them all nonetheless.
Okay.
I'm sorry, totally not a Russian. Marissa will be back for her normal programming tomorrow. Marissa just got a little wet today, so she couldn't be on stream. I don't know what I'm saying. I shouldn't say stuff like that. But this is bullcrap. They need another 30 days to give them discovery that they already sent over. No, you go home tonight and you look at what
Right on the 2024 case that you had filed a motion for specific discovery in that case, outlining the items that you were looking for. Those contained within the chalk that was submitted.
Your Honor, I haven't received any response to the motion per se. You know, I think it should be responded to by the Commonwealth, and I would like a written response at some point to the motion. I don't know what, you know, there's probably some things that comply in here, but, you know, there's a list of it's about a dozen things, Your Honor, 13 things. I know it's certainly not completely responded to or complied with. So I think that I would ask the court to hold the Commonwealth's feet to the fire, provide the written responses, provide what they're willing to provide without a court order, and then we'll litigate whatever remains so that we don't have to burden the court with going through 13 items. So I would ask for a response, and maybe in the 30-day time frame, I would ask for that my motion be responded to in writing so we can kind of frame the issues.
Okay. Has there been a response to your request for a bill of particulars that was ordered on the last date?
No, Your Honor.
That was ordered. That's
I can tell the court that I'm aware that Mr. Mello was working on a bill of particulars because he called me at one point with a question relative to the response, but where he was in the process before his surgery, I'm unaware.
well.
All right. And on our last day too, Attorney Brady had filed a Rule 17 motion seeking records from a third party as well as directly from the record holder. I issued an order after our last hearing that notice be given by the Commonwealth to the third party as well as the record holder. ADA Cosgrove, do you know whether that occurred for today's hearing?
I'm not aware that notice was given. The third party is here today, but I don't believe that she was notified. I'm happy to take care of that today if I can, Your Honor.
Okay.
In terms of giving her notice.
So, Judge, I'd ask you to allow the motion. This is essential discovery. I'm not going to reiterate my written motion, Judge. We laid it all out there. The government's own reports that have been disclosed to us note that Ms. Gattani deleted items from her phone. She told the policeman, "I'm deleting things right now," literally said that. And the policeman, the officer, recorded that in his report. So we have an absolute good faith basis to see that she destroyed evidence. So the Commonwealth has given us some text messages, and such as they are, there's problems with those too, where there's photographs, let's say, that you can see that there's like 6 attachments and you can only see the top one, the screenshot. So there are issues there, and we'll contact Attorney Cosgrove, and I'm sure we can work that stuff out. But it's a woefully incomplete representation of what we need. And so this Rule 17 motion in these circumstances where she is 100% admitted to destroying evidence, we need the evidence from the third party because she destroyed her copy. So we're asking that the provider give us all records of Ms. Gattani's cell phone so that we can hopefully see what was there, what was destroyed, and at least isolate. Some providers, they can give you all the text. Some providers don't have it. We have to try to reassemble the record and see what she deleted. And if she's deleting text messages between her and the police, that's important. And she's also, another point on that, Your Honor, is that Attorney Mello is, I would contend, improperly speaking with Ms. Gattani in cell phone conversations. And he's now a witness.
That may raise that issue down the road as well, too, in terms of the prosecution of that particular indictment of whether.
So there's all these issues that I just want to litigate this case, Your Honor. I want to get my discovery, and I want to litigate this case. Just a constant stream of drama from Attorney Mello that I don't need. I want to represent my client, and I want to get this done, and I can't do it.
I'm certainly confident in ADA Cosgrove's ability to compile everything and to get it to you within the 30 days. ADA Cosgrove, so you're aware that there were orders issued after our last hearing for everything to be provided by May 8th. I know you're just coming into it, but I just want to make sure you're aware of the framework.
I know that with respect.
Thank you so much, Jim Cox. I'll read the names later.
Some of these motions I am frankly learning about for the first time. I have just learned about yesterday. With respect to the motion presently before the court that Mr. Bradel asked that you allow today, my understanding of Mr. Bradel's proposed next move from the defense is that he's looking for additional discovery from us so that he can file a McCarthy motion or something of that nature. I would suggest that the phone records that he's seeking are not implicated in any McCarthy motion. It may be that he's missing some grand jury minutes, which I don't see any reason why I should not be able to get to him quite quickly now that I've been provided with the specific grand jury minutes that he's missing. But it seems that any use of the cell phone information he's seeking, if indeed he's entitled to it, is something that could be done post-McCarthy motion. I don't see any harm in deferring ruling on this motion to give the alleged victim, who has a statutory right, I believe, or certainly a right under the rule, to be here, to be notified, to be represented by counsel, and to be heard on whether or not Your Honor is going to order that her cell phone records be turned over under a Rule 17 motion. If the ball was dropped in giving her earlier notification, I'm standing here representing the Commonwealth. I'll take the hit for that, but I don't think the alleged victim should be punished, particularly when the problem can be so easily rectified. I make bold to say that this is probably not the first time that a prosecutor has stood in front of you and you have inquired, was the third party given notice of the Rule 17, and had the answer back, no, Your Honor, that didn't happen. And I'm sorry it didn't happen in this case, but I think it can be done and proper procedures can and should be followed.
All right. That brings us into the next issue and the motions that you had filed with regards to that particular witness. Are you prepared to address those, Attorney Braille?
With respect to Rule 17, Your Honor, I'm sorry.
With regards to the motions that were filed by ADA Cosgrove.
Oh, in terms of a protective order?
Yes.
Yes, Judge. So in the email that I provided to the court, you know, we pledged to that we would not act on anything and publish anything or use anything.
Okay. And I know, before you go too far, there was also a request that the filings be impounded as well. Are you objecting to
No
that?
objection. No objection, Your Honor.
Okay. I do find there is good cause based on the privacy issues raised in the filings to allow the motion to impound. I did receive your correspondence with ADA Cosgrove laying out how to address that particular issue and to clean that up. So it seems like you've reached an agreement on that. Is that accurate?
Well, I'll let Mr. Bradel speak to that. I don't know if he's assenting to my entire motion or.
Well, so Judge, we talked, and I think counsel's right that we have a agreement for the court, and counsel can correct me if I'm wrong. Counsel asked for either the 30th or 30 days, whichever one is fine with me, of 30 days, I think it was, to get a hard drive in a form that they believe is appropriate and get that to me. So we have the drive that was given to us. Many of the alleged sensitive items on there, we can't open, number one. Number two, I ask you to kind of take a look at the global situation here. So the one item that we get that has usefulness to us, well, not the one item, but something that has use to us in discovery among things that are not really very useful. We get this hard drive, and the Commonwealth wants it back. They want us to look through it and figure this out and that out. They're giving us a project. They're not giving us our discovery. And now they want it back, and we can't use what's in there that helps us if we have to give it back. So we don't want to give it back. We want to use it and continue to use it in our preparations, but we're not going to utilize anything. And I don't even know what they're talking about as far as what they are concerned about in the drive. I have a feeling that, and again, present counsel accepted, I have a feeling that when Lieutenant Tully, I think in a good faith effort to try to comply with that May 8th deadline, gave up the drive in haste to try to comply with that deadline. That's the one thing they did comply with on that deadline, was they gave us this extraction. It's full of exculpatory evidence, and we need it, and we're using it. And the fact that he inadvertently left, you know, school records or whatever else is in there,
They
we're
can't
not
open the hard
look
drive.
at them or do anything with them. We've pledged that in an email to him, to council a while ago. So we've agreed to that on the record, and we'll do it here on the record that we're not going to do anything with it. We have it, but how about we get our discovery, and then we'll be happy to give the copy back. We'll do it here. We have it, and we're not going to use it. Council needs this time to give us another one. Let us use the one we have under those conditions until then, is what I'd ask.
And you and your client have agreed not to disseminate any of the information that is on that particular drive in any fashion?
Yes. I believe the date of the email, I pledged that to council, whatever the date of that email was. And from that day on, with respect to the phone extraction, this is just applying to the phone extraction, and that we won't disseminate anything. Absolutely. Just among the defense team, of course, but.
So my understanding is that the Commonwealth will provide the defendant with a appropriate copy of the drive, appropriately redacted, within 30 days, and that at that time, Mr. Bradel will return to us the original drive. And then no use will be made of the information other than, as Your Honor has indicated.
Okay. And Judge, just while we're on this drive, I don't want to belabor this, and counsel and I have had a discussion about it, but I just want to state for the record that it appears there were some, I'll just call them extraction issues with respect to what was given over. And I've spoken to counsel about it, and they're going to redouble their efforts to make sure that everything is accessible and provided.
Right, and certainly
they should get a new tech
the
department.
Files themselves in an extraction report, that you just can't open them without the appropriate software. That's something that your expert,
Right.
if you have one,
Yep.
is probably going to be the one to open it. That most of the files you're not able to open without proprietary software to get into those particular areas. So
We went through that, Your Honor. Ms. Healy spent a lot of time on the phone with Celebrate, and that's how we were able to figure out that there were certain things that should have been checked that weren't checked. And we're not suggesting, we don't know what happened or why it was not, but we just want to get an appropriate copy. And
You don't have to suggest, we all get the gist. They tried to hit and hide another piece of evidence,
Your Honor,
just like the library video.
Having filed a motion to impound my motion, which Your Honor has allowed, trying to be absolutely cautious with it, I provided a copy, of course, to Mr. Bradel, and I filed a copy with the court. Given that the information that the Commonwealth is concerned about the confidentiality of is the victim's, may I make a copy of it available for the victim to examine?
I'm sorry, I didn't hear the last part of that.
May I make a copy of it available for the victim to examine? My motion to the motion relative to the drive.
Attorney Bradel, any issue with that? I think it simply outlines the Commonwealth's concerns of what happened and their steps to address it. So,
I've never seen the Commonwealth sharing discovery with a civilian in an ongoing investigation, but if they want to do that, I don't really know if I have any standing to object, but.
Well, I wouldn't call it discovery, it's her information.
correct. All right. Madam Clerk, in terms of a
Hello. Well, as are you going to talk or are you not going to talk? Well, I'm going to start talking, then I'm going to stop when you start. As always, this is this really what you do in in the Commonwealth, can't turn over evidence after 3 court orders. When you turn over evidence, it's not complete. When you turn over evidence, you need a special kind of software to open it. You should be able to do that without accessing any special softwares. You don't know what evidence has been turned over. It'll take you 30 days to go home and look at which minutes from a grand jury your friend, boss, whatever Mello is, hasn't turned over. And now you want to give evidence to a party in the case that you haven't turned over to the defense, if I got that right. This is weird. And Jim Cox, thank you so much for the 10 gifted memberships to Palola's mom, Major Mom, Roxana McLaurin, Patty B, Atheist and Sassy Pants, Just Before I Go, and Shenanigram, Mexican Vader.
The 27th is better. No, 27th is a better day. All right. So 88 College Grove, Attorney Bradel, anything else to address this afternoon?
So Judge, I appreciate you going through all this stuff. So my notes here are Rule 17, disqualification and sanctions, and the bill of particulars. What did the court want to do in terms of deadlines or rulings or?
So that's why I wanted to make sure we had covered everything before we set those next dates. So what I'm going to, 88 College Grove, anything else to address?
I think Your Honor has covered the waterfront.
Okay. So I'm going to order, I know you asked for 30 days, but it's going to be 21. So it's going to be June 13th for compliance on the outstanding discovery issues to enable us to have a future hearing on June 27th, Thursday, June 27th, 2 p.m. At that point, we'll address, if necessary, an evidentiary hearing on the motion to disqualify. Also, that will be the Rule 17 will be heard at that point with proper notice given by the Commonwealth to the third party as well as to the record holder.
Your Honor, I'm sorry, I'm away that week in June. I just realized. I wouldn't have an objection to.
That June 13th will be an out-of-court compliance date, but Madam Clerk, what's the week before look like?
I think June 21st was the next best date. Oh no, I'm sorry.
That's when I'm going away, judges. For the hearing date, I'm going away from about the 21st, returning July 2nd.
June 20th would be a week from the 13th, right?
Could we?
Does that work for you, Mr. Bradel, if it works for the court?
I just don't want to set it up for failure, Judge. I think I'm away that day as well.
The 20th as well?
I think so, yeah.
I wouldn't recommend July 4th. How about July 11th, if we're looking at Thursday?
Given my issues, I'm not going to object to July 11th, Your Honor, if that's all right.
Do we have our July schedule?
So,
July 11th isn't a Thursday. It's a Tuesday.
All right. All right, so by agreement, July 11th, 2 o'clock for hearing on those issues. Discovery compliance, June 13th. Anything else, counsel?
And I'm sorry, Your Honor, I'm afraid I'm a little slow today. What matters will actually be on for hearing on the 11th?
It'll be the motion for disqualification as well as the Rule 17 hearing. And if there's any other motions that'll be filed and need to be addressed on that day, if you can get them filed at least 2 weeks in advance, and we can address them that day as well.
Thank you, Your Honor.
Then my calendar is wrong. It says.
all right, I apologize. Chair
Sorry.
Carney, your matter is continued to July 11th at 2 p.m. for hearing on Rule 17 motions and the motion to disqualify. The Commonwealth shall provide discovery by June 13th.
Thank you.
Yeah, it is Thursday. I just put it wrong in my
Your Honor.
calendar.
Madam Clerk, anything else? Do we have final surrender here? Okay. I'll take a break, yeah.
Well, that was interesting to say the least. And as totally not a Russian bot pointed out, they can make this trial date any day they want, because this trial will go away exactly the day after Karen Reed is either acquitted or found guilty. That's what this case is all about, is keeping Aidan Kearney out of the courtroom and putting a gag on him so he can't talk about the Karen Reed case, because they know he's dangerous to especially their prime witnesses. We've seen how well their prime witnesses have been doing. Jennifer McCabe, honey bunny, you lie more than I did when I said I would love my ex-wife forever. It's this is a complete stall show, show, everything bad show. All of this is horrendous to watch, how they treat a case like this. They bring a case, they have to go through 6 or 8 lawyers before Mello accepts to be the lead on the case. He shows up with the weirdest motions. He attacks Bradel's honesty. He was that stupid guy who said, well, it's on the internet. Yeah, well, you have to bring evidence into the courtroom. But I can't bring the internet in here. How can this case go on? That's and one thing is the Commonwealth not doing their job, but why isn't the judge saying this is a travesty? In Denmark, we have a saying whenever I'm in court and we're trying to find a day for the next court meeting, they are always asking the defense attorney first, because it's the state that brings the case. So if the defense attorney are able to meet on June 11th, the state will provide a prosecutor, no matter if it's Mello, if it's I didn't get the name of Mr. Time. He sounded like he was older than dirt. Or it'll be the brand new prosecutor who just got the job yesterday. They will get a bundle of files and they will just go to court. It's their job to bring the case. They are the state. The state isn't Mello. The state is the entire DA's office. And they should every time be well prepared. He didn't even know what the stuff Bradel was asking for was, because he doesn't know what evidence have been turned over. Because Mello was writing a piece of paper and we talked a little bit, and then maybe something, I don't know. How should I know my own case? And all of this is just to protect Albert's and McCabe's. All of this is to keep Turtleboy. They couldn't get gag orders on Turtleboy. They tried with each and every McCabe and McAlberts, not McAlberts. Every McCabe and every Albert tried to get gag orders against Turtleboy. That didn't happen. So they charged him with witness harassment. That witness harassment hearing went so badly that they had to hit him with a honeypot action. And I've said this multiple times, Turtleboy was an idiot. He went to the honeypot and he did what all men do when he put his bee stinger in the honeypot. And now he's in all of this. He spent 60 days in prison because of that. It was a clear setup from the state, allegedly, approximately. I don't know. I don't give a F. Yes, it was a setup. That woman, LG, clearly showed her beef curtains so Turtleboy would get in trouble. She never called the police. She called the DA's office because she had their private number. This is absolutely a travesty of justice. I know people don't like Turtleboy. I know Turtleboy is dangerous to the state's case, but this could be you. This could be me. Well, it couldn't be me because I don't live in the US. But this could be everyone. This is how Massachusetts wants to run their cases. And yes, they are not too it's not above them to run a honey trap on a citizen journalist because he's connected to the Karen Read case. And the Karen Read case, which we have seen now, tomorrow will be the 17th day, Brian Higgins Day. They haven't proven anything. I went away to Tennessee a week ago, and all the good witnesses was coming in. And what do we know now? Jen McCabe is the biggest POS on the planet. She's the meanest girl, and she sits there with her crooked teeth and her horse face and talks bad about everyone from Carrie Roberts to Karen Read. Then we had those two weird sisters in saying, yeah, Karen overreacted a month ago, but she was so nice she paid for everyone. That's the entire case against Karen Read so far. Is Bri likes to grab men's behinds. Jen McCabe really likes to talk about all her friends. Carrie Roberts seemed like she was just happy to be able to hang around the cool girls club. And now the state is trying to keep Turtleboy away because they know they have such a bad case. This is an absolute travesty of justice. I'm sorry to say it. I didn't know you would be live streaming about this today. Going to be replaying to catch up. Well, do it via nice. No, I just I got notified 15 minutes before that the very, very great Marissa had a Zoom link. That's why I went live. Karen can't be any one of us because I saw Turtleboy did. I don't think that was a kind of a stupid thing. He put up on Facebook. Imagine if the races had been different. No, this has nothing to do with race because this is all about being connected. It's all about who knows who in this case. Again, the lead investigator, Proctor, should have recused himself because he knew everyone involved. Brian Lang should have been recused himself because he knows everyone in this case. The only one I don't know if he knew everyone is Bukaki, because we haven't heard from him yet. But the rest of them, they went to school with everyone, knew their kids, knew their wives. It's such a travesty of justice. And all of this, why I'm here today, is because Aidan Kearney, a weirdo just like me who has a YouTube channel and a blog, started digging into it. And now they are prosecuting him to get him to shut up. Fluxy! Exactly. All of his digging and of whatever, because he talked to the defense team, which is perfectly legal. So did the Commonwealth. I don't know how much they talked to Kathy Daffy, but she, for an FBI agent, she's either become very late in French or hit her head against the wall a few times because the stuff she puts out there is really, really stupid. Jen can't help her inherited horse DNA. No, I know Mr. Ed was her dad. Prosecution proved that Karen Read was an outsider and all these witches were jealous of her. Also, that Karen Read tried too hard to fit in that group because she cared about John. I agree. Actually, I was thinking a little bit about it while I was away this weekend. Imagine if you were one of the people's down there's girlfriend, like Caitlin brought in her husband, lovely fella, and he's not part of this YouTube universe, but let's say he wanted to ingrace himself with all of us and buy us a round of drinks and sit there and talk and just try to be a part of her life and really don't understand that YouTube world and why we have all these weird jokes we make. And we just turned on him and said, you don't own a camera, you don't own a laptop, get out of here, brother. Because that's kind of how this group is so tight that if you're not from Canton, if you don't have at least 4 generations of interbreeding with the McAlberts, you can't talk to anyone. What Karen Reed did, she paid for everything. She helped John's kids. She wanted to be friends with the nasty girls, even though they are the nasty girls. She paid for dinner without anyone knowing she paid, because she wasn't like one of those who said, "Oh, so should I get the tab?" We all know those people who are sitting and counting and saying, "Oh, that's going to be a easy bill tonight. I'll pay the tab." No, she was a super nice lady, and she really, really, because she cared for John, she wanted to be there for John. And what did she get? She got scorn and disrespect. Even if she'd been with John today, John was alive, they would still be treating her like she had leprosy. Trooper B knows Brian Albert. Of course. Why am I not surprised? All of this because of what happened in Aruba. Well, Turtleboy is kind of it's just another continuation of the Karen Reed case, because they need him to not talk. That's why he's in trouble. How was my US trip? Glad you didn't get thrown in jail. Well, my US trip was great, except they wouldn't serve me alcohol at an arcade. And Val turned full Karen. You would have loved watching him when he looked at a mixed race girl and said, "So you don't serve foreigners in this establishment?" That was fun. I do look like I picked up a little bit of a tan, but I was out in a long time. Thank you. Was Jennifer O'Keefe investigating something about how? I know there was some rumor about something with some drug, but I don't think so. In my opinion, I have two theories I always go by. One is, why make this so hard? Just make it a slip and fall, and you wouldn't have been in all this trouble. I think he went into the house. I think something happened. Either he fell down the stairs to the basement, or maybe they were doing the thing Bri loves, grabbing asses, and Chloe misunderstood it, jumped on him, and he hit his head, got a concussion. And that's why he has vomit in his pants when they tried to get him up. And either he said, double middle fingers to all of you, I'm going home, went outside, fell over. They found him and said, "Oh, Jesus, what are we doing?" I don't understand why they pin it on Karen. It's a slip and fall, could be reasonable, easy to explain. Is Colin involved somehow? After seeing that fight video, he's a neck puncher. That's the lowest kind of fighters. I don't know. I just don't know why they tried to pin it on Karen Reed. They could have made this a slip and fall, but I think How's Long to Die in the Cold kind of indicates when the phone rang that morning, Jen was thinking fast, and she isn't a fast thinker. And that's why everything became a problem. I think that's why she called the Albert residence 3 times from outside the house. I think if it was Bri who had done it, have found him, he would just say, "Oh, he must have fallen when he walked home," because he said he was getting so drunk. That's why he has vomit in his pants. He said, "I'm going home." He must have slipped and hurt his head. They never expected Karen Reed to have money and brains enough to make a case against him. But I don't think he had anything on them. I don't know if they were dirty. I don't think any of that. Tomorrow will be interesting, and whatever Trooper Proctor testified, this defense team is destroying about 97 of the prosecution's witnesses. I wonder if they will get Trooper Proctor to plead the fifth. I don't think a police officer can plead the fifth. Because if he's pleading the fifth, I know there is an internal investigation going on about him right now, but if he's pleading the fifth, that's going to be really, really interesting because that's protecting himself against self-incrimination. That means he potentially have done something wrong. And you can use that against him in the court of law. But at the Canton PD station or state police, wherever he works, je ne sais quoi. Tomorrow there's no hearing. There is a hearing. There's a Karen Reed starts tomorrow at 9. They wanted to blame it on a plow driver originally, but that didn't work, so they had to find a new fall guy and land it on Karen. Yeah, and that's the stupid part, and that's I don't know if any of there's a lot of new people here today. I'm in Denmark we have a different jury system. I've been doing this for 13 years, and I can tell you, almost everyone who sits in the witness stand because they have done a crime is the smartest person in the room, in their own mind. And that's funny because hardly any of them are that smart, but they believe I can spin a tale, and then they kind of get caught in it, and they say, "No, I can spin another tale, and another tale, and another tale." And in this case, you have so many smart people. Bri is the ringleader. He is the guy saying, "Hey, man, I'm the fugitive cub from Boston Payday. I'm gonna show you all how you're gonna tell this story." Then you have the IT guy, McCabe, who is stupid enough to put things on text. If you do crimes, don't write it on your phone or your computer. Then you have Jen McCabe, who is the biggest B word on the planet, who can't keep the script. She's really good when she's being coached by Lally, but her inner I'm a she-witch comes out when she has to testify. And all of these three people believe they are the smartest person in the room. But their stories just doesn't add up. 7 different reports and grand jury testimonies have been written down falsely. Jen McCabe, GE retardé, if you think that's gonna fly. Yeah, that's a weird one too. Why? If this guy represented Denmark, then Denmark is doomed. Well, I don't represent Denmark. I never have. I wish I was good enough to play football. But yeah, if I was on our national football team, we would be doomed. Yeah. Sadly, that's a true statement. Just like the one who said, I'm a big grifter on Twitter today. I am. Jen said she turned her phone off before she fell asleep. How did she answer Karen's call? Well, she always had her ring. No, that wasn't her who always had the ring on if her kids rode home. Addie is an awful person, in your opinion. Well, I don't know her. I'll have to check her out after. Yeah, he can plead. Everyone can plead the fifth because it's in your constitution. But what I'm really interested in is how it'll go for him if he does that. No. I'm too fat, too old, and too slow. I am. That's because I'm trying to be like Plevin. Grift, baby grift. Don't hate on the grift, y'all. Yeah. Well, it's kind of like all YouTubers are grifters somehow because we're either grifting for super chats, views, likes. Please like and subscribe. Doing the YouTube things. I just love that people are thinking I'm morally above it because my channel is pure. No, you're not. Everyone wants another subscriber. Denmark need less cheesecake. Next week, because on the Bev, I think have taken the entire week off next week. I will be baking something. most likely not a cheesecake, but I have those cherries from FD Food Fairy, so I will be baking something, and I have those new measuring spoons from Legendary, so I can do it in the weird American way instead of doing it in the real way where you weigh things by the metric system. So just a little heads up. Oh, we have a person with special insight. Turtleboy is behind all the hate mails. I hate mails. I love loving mails. Witness stalking, etc. Which witnesses have been stalked? You didn't know about that, or you have a convenient excuse again? Oh, it seems like a detractor. I missed my trolls. Nima. Oh, she's in Vermont getting Chloe. Alpha Dog. Oh, he doesn't hang out here anymore. I don't get the good trolls anymore. But to all the males out there, don't be a hate male. Be like Bri. Be a age grabbing, loving male. Just like me. Me and Valhalla, we were very loving males the last week. We had a wonderful time. The Valkyrie did look upon it with a certain disapproval, but the hard ones were the hard ones. I think these people are awful human beings, and I don't think anyone will want to visit Canton, Massachusetts after this trial. No, I'm not stopping by for mac and cheese at the PADA, whatever it's called, the restaurant. Didn't Miss Proctor start the stalking? Probably. If too fat, too old, and too slow, then just identify as female and join the women's team. I actually used to, when I was, how old was I, like back then? Maybe 10, 11 years old. We always played against 14 and 15-year-old ladies. So that was 2 tiers or 2 ages above us. So we matched up equally. That was before equality was there. So could you imagine my fat ass running into a woman a third my size? She wouldn't stop flying until the match was over. Thank you so much, Celestial Force. Back with a vengeance. I am back. Back again. Well, be nice to new people and go check her out. And if you don't like her, it's fine. Not everyone loves me, but that's fine. There's always a new channel, always a new host. Or in the end, you can always watch Lawn and Grim. So, what was my most favorite thing I did in Tennessee? It was breaking my no hugs policy. I hugged a lot of people. I liked it. I hugged a girl and a guy, and I liked it. No, my favorite thing was just meeting everyone. It was an amazing thing because when you're on YouTube, you are the YouTuber. I'm the broken baker. I can't be the broken baker 24/7 because he would get really tired sometimes, and then I might get a little mad and a little cranky. But meeting everyone from Wendy Yates to Dave, I met Dave before, Wallstrom, Diva, Vegas Rick, everyone having Aaron come down and say hey to us. That was just that was my favorite thing. That Friday, that Thursday and Friday, spending so much time in Dollywood, just talking to people, meeting Gosney. Not as much. I didn't talk that much to Gosney. I talked a lot with his wife. We are fellow baking enthusiasts, and that was wonderful. And I always love seeing new cultures and stuff like that. But it was the people we met, and that people who were there weren't phony, because that's one of the first advice you always get as a YouTuber is don't trust anyone. Because, as I said earlier, we're all grifters. We all want to be bigger. We all want to be better. We all want to be. We need to have an ego because we are filming ourselves for an obscene amount of hours. So you're wondering a little bit, who am I meeting? Am I meeting the expert, or am I meeting Billy Bob, who's just an a-hole, but turns it up when he goes on screen? And I said this to people out there, over there. When I walked into that porch Tuesday night, everyone was someone I knew from online, and there were no breaks in. It wasn't weird. It wasn't like, you come into a new school and you're thinking, who are these people? We talked till, I think I got to bed at 3 in the morning or something like that. We was sitting out there for 4 or 5 hours just talking, and that was the absolute best thing, to see that all the people I met in Tennessee were great people, and people who are not phonies. Because you hear so many bad things about YouTubers. You hear so much. There's probably people talking about me as well. And some of it might be merited. The most of it, it's Jamie talking badly about me. But it's really nice when you meet people and you stay with them for 7 days and they never change. Of course, you have your ups and downs because you're tired, but it's the same person. Really, really lovely. Really, really lovely people. Not everybody is a troll. Sometimes it's just a moron. Well, I like the color maroon. It makes a little fun on the channel. A real question: was the salted caramel cheesecake that bad? Your face was it? I really disliked it. The texture of it was just too mushy all the way through. The taste was really bad. But still, the vanilla bean was worse than that. I like Vegas Rick's cheesecake. That was good. Can you make them come to Denmark? I probably could, but it's way too expensive. It's easier for me to go over there than all of them coming here. I'm just as much an a-hole in real life as I am on here. You're welcome. Yeah, I thought you would be better when I met you in real life. Nope. It was absolutely knuckle dragging stupidity, and that was fine because that's how we are. No, he's a lovely fella, and Diva is even better. Hey, Miss K. Griff. Yeah, I think we have a good crew, and again, not everyone loves everyone. That's how it should be. Well, we're ending because we watched the Aiden trial. They got delayed till the 11th of July, and all in all, it was just Mello hasn't filed the orders he was ordered to, and haven't given them the evidence he was supposed to, and the guy who took over don't know what evidence he gave them. Yeah, so that's like that. You don't even like 7 people. Oh, that was a good time. And is there a wedding in your future with Little D? You all sure make a cute couple. Oh, and moon pies forever. A girl doing kiss and tell. So when our anchor baby is here, we might look at it. And moon pies isn't that good. Speaking about troll, there's an artist from Denmark in Minnesota creating a huge troll. Yeah, we have. I think we have 2 of those on my island. Vanilla Bean was really, really bad. Court is over. It was just a short hearing in the Aiden Kearney Turtleboy case. Did anyone do the walk of shame in Dollywood? Let's just say there was a lot of Dollywooding going on. Yeah, I said it. I never got to Hooters or Twin Peaks. I really wanted to, but if any of you starts following the expert and clamor enough for it, then Dollywood 2025. But if we make Dollywood 2025, you should talk to Wendy H and Aaron Olivier and hear that we are not as bad as people think we are. And you should all come and see us because it was super fun doing it. It was very loose, like sleeve of a wizard. That's a Borat reference. But it could be fun if more viewers had shown up in real life. I know it's a little daunting meeting people and showing yourself online, but it could be fun to meet more of you. And getting to hug Aaron was great. Hooters and Twin Peaks were not going to happen with you in Vegas, Rick. You know why? Yeah, because you're weird. Me and Vegas, Rick, we just see a bundle of snakes and we like to throw rocks at it just to see what happens. But little impromptu stream. I'm gonna jump off. It's almost 10 o'clock. I have to get back to a normal sleep schedule. We already made a second tour plan. It's far from Alberta. You want to talk about being far from something? I had a 27-hour trip yesterday. Can't imagine a squirrel at Hooters. There's a lot of beavers in there, I've told. No. Back to normal scheduling tomorrow before we break from normal scheduling again next week. Tomorrow will be day 17 in the Karen Reed case. Higgins takes the stand at some point. Monday is Memorial Day, am I right? I can't remember American holidays. Tuesday is Bev drinking White Claw Day. Wednesday is Bev getting her nails done. I don't think there's any hearings next week, but tomorrow we will do the Karen Reed day 17 hearing. I will be there. Jamie might be there. I think Marissa needs some sleep, but I'll, if she wants it, she has the back door to me, so she can just jump on. It'll be lovely to have a little talk about how her time as a streamer has gone, because it's not as easy as some people make it look. Tuesday, there is court. Well, I'm a grifter and a liar. Get over it. New Orleans for a meetup. Yeah, a back door. Yeah, that's his medical document, is to tell that there was tearing going on down there after Dry got too close. Yeah, you go up to the expert, and then you can join in the sweepstakes before New Year. If anyone figures out what he's an expert in, I'll eat another piece of cheesecake. If you weren't there, you can still be Dollywooding. Yeah, we don't peck at your Dollywooding like hens. It's crow with the roosters. That's all I can say. Higgins will be, I don't know, there's so many rumors. Crawford flipping, but if he's flipped, the state wouldn't bring him. So I think it'll be Lally talking about what shoe size he likes, if he's more fond of cherry cheese pie or cherry cheesecake or normal cherry pie, and then ask why he went to work at 1:30 in the morning. And then Alan Jackson, I believe, answered yesterday. Alan will be the one who cross-examines him, and he believes he can do it in a day. Why is Marissa saying back jaw Jeebus? Is Rick here? No, I haven't seen Rick all day. He's an expert in being an expert. Well, that's not really an expertise. Cock-a-doodly-doo. Oh, two minds, one thought. She did great. Wouldn't mind Marissa as a regular. Maybe have a backup before we eventually break Jamie. Well, Marissa do have a life. Yes, you do. Thought you were coming to the US for the Karen Reed trial. No, I was coming to the US to meet people. I thought the Karen Reed case would be done when I did this trip because that was supposed to have started in April. So I thought I would be home free and I would have grifted the heck out of that and I could have flown first class and everything. And now it's going to be a 45-week trial. That was more like a little anal tearing from all the graphology. Yep. Hey, Mexis Jen, how are you doing? Hope you got home without too much trouble. And lay low on the dolly winning for a while. Well, this is me when I'm too tired after 27 hours. Tomorrow I'll probably just be sleeping in my chair. What? Who? Before this devolves into an expert stream, I'm gonna see if I have a sign off. I got a new intro today because they could yell at me for that yesterday. Hasta la taco. See you in the morning. And as always, sorry for my humor. I only have one thing to say.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor. 100, because it is 100% correct.
Objection, Your Honor.
See the lawyer's face? Okay, we have to go back and they.
Widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
Wait a minute, I need this story time.
Everybody has.
Everybody has.
Everyone has slept with his mother.
If I showed you.
Oh my God.
I'm having a Jamie moment. And the way he just said it, he was just like, everyone there. Things on YouTube.
Mr. Randolph, do you?
I got that against the man. You don't know.
Called him chicken shit.
That's right, you was chicken shit.